My ladies, my lord,
Yes, Mr.
we were
Wallace.
considering before the adjournment the nexus, I think Lady Justice Whipple described it as, between the unlawfulness and the restitution claim, which brings me on to the Supreme Court case, the ITC case, and the principles, and hopefully it'll become apparent in a moment how the point made we were discussing just before the adjournment and the link. The ITC case, the Investment Trust Company's case, is at tab 13 of the authority bundle, page 318. This is a complex VAT case, and I don't.
I don't be rude about complex VAT cases. Some of us
I know.
enjoy them.
You'll know much more about it than me. But what we do know is HMRC successfully resisted the claim for the recompense of the VAT. But that's by the by. It's the facts that it's the principles that Lord Reid sets out, and. This is the latest case on the latest Supreme Court case on restitution. There has been a handful of cases over the last 20 years or so, but the principles are set out quite clearly, and the discussion very instructive. Can I take the court straight to the relevant parts of Lord Reid's judgment? And I think this was I think all the other justices agreed with Lord Reid. I don't think there's any either. Dissenting or concurring judgments. No, everybody agreed. Page 333, the common law claim, and paragraph 24 sets out the four signposts. He's relied on Lord Steyne and Banks Financier there. Now we've seen that for those four signposts replicated in a number of places in the documents. Has the defendant benefited in the sense of being enriched, or we say inevitably so because it hasn't paid for the care of this child? Was the enrichment at the claimant's expense? That's the hard-edged issue that we've got to consider. Thirdly, was the enrichment unjust? I'm going to come back to that in a moment. And fourthly, are there any defences? Are there any? The fourth limb is irrelevant in this case. It's the third limb that I want to address the court on, because it goes directly to my Lady Justice Whipple's point just prior to the adjournment. Was the enrichment unjust? What's striking in the first instance is that it doesn't say on law that the test is not, or the feature is not unlawfulness, it's unjustness. And there's a reason why the law has developed in that particular way. That is because the law of restitution derives from equity. Unjustness is an equitable principle, and it's a matter of what's fair and just. Now, the analysis in the CP case and the assumption hitherto in this case is that unlawfulness is a necessary precondition of restitution. It's not. It's unjustness. Unlawfulness may lead to injustice, of course, but that's not necessarily the case. So, have we got unjustness in the present case? I know that's not the primary issue this court's constituted to consider, but it's a highly relevant one, especially given Milady's comments. Is there unjustness in this case as opposed to unlawfulness? Well, what we know with respect to ground 2 in the High Court is that the judge there, on the facts, found that it wasn't irrational. He says in terms in the judgment, a statement of the obvious, that the threshold for irrationality is a high one. We all know that. Then we ask the rhetorical question whether the high threshold of common law rationality is the same as unjustness for the purpose of restitution. In our submission, it must. The answer to that must be no. There isn't. One doesn't have to hit the high threshold for irrationality in order for there to be unjustness. And because there's been a finding of irrationality, it doesn't mean that there isn't unjustness, because for the reasons we set out just before the adjournment, there is plainly unjustness in this case. Now, restitution, we also know, is not a discretionary remedy. It's not a remedy that the court determines on the facts of the case. It must be a transactional issue in that there must be a passage of money for something that should have been paid for by another party, whether in the public or private sphere. And so we say that there is indeed unjustness in the present case. Now, it's apparent that there's been no argument about unjustness in this case. The judge below didn't address it. He didn't have to because of the findings that he made. And the court may find that that is a very important point in the context of this case. So,
but the case you presented below was that there was unjustness because of the unlawful dismissal.
Absolutely.
And you didn't present a case that there was some broader concept of injustice divorced from
No, we didn't, my lord. No, must be quite frank about that. In the light of the finding of the High Court and the refusal of permission to appeal that point, and in the light of my lady's comments just this morning, we say that that is the proper analysis of the law of restitution. It is very striking that unjustness is the keystone, or one of the key features, rather than unlawfulness, and there's good reason to do so. So we make that point at the outset. Can I just take the court through a number of other points in Lord Reid's speech, if I may. His lordship deals with was adjustment at the claimant's expense, page 335, paragraphs 32 and following, and it's under the heading general discussion at 337. It's a general discussion of that issue that we find the most illumination. So we see at paragraph 30, and I'd invite the court, you'll see the parts that's sidelined. I'd invite the court to carefully consider those paragraphs. If I can just pull out in short form the principal features. He agrees with Lord Gough in the Littman-Gorman case, or he cites with apparent approval that recovery of money and restitution is not a matter of discretion of the court, it's a matter of right. That was the point we made a few moments ago. And then he cites with apparent approval the comments of Lord Stain in the Bank Financier case, that unjust enrichment ranks next to contract and tort as part of the law of obligations, and that's a point that we'll return to in a moment or two. But then goes on, importantly, over the page at 338, to caution against sloppiness of thought in citing a 1760 case, a sloppiness of, it's probably the 1923 case most, whichever, citing those two cases. A long time ago. Well-meaning sloppiness of thought isn't a proper way of determining.
We'll seek to avoid it, I promise.
But yeah, absolutely, and we'll seek to avoid the court to persuade the court to do so. Then we've got the four questions, or the four signposts at paragraph 41, referred to Lord Clark's judgment. 42. Oh, the second half of 41. The questions are not themselves legal tests, but a signpost towards areas of inquiry involving a number of distinct legal requirements. In particular, the words "at the expense of" do not express a legal test. The test can be derived by Jesus of those words if the words were in not as if they're in the statute. 42. The structured approach provides the four questions provided by the four questions does not therefore dispense with the necessity for careful legal analysis for each case. Carrying out that analysis, it is important to have forefront of the mind the purpose of the law of unjust enrichment, designed to correct normative defect transfers of value, usually by restoring the parties to their pre-transfer positions. I think we all understand that through the different lenses that of English law, and that's what we're contending for. And this is where the phrase corrective justice has come from. It's paragraph 43. You'll recall that I mentioned that before the adjournment, and that is essentially what we're seeking, corrective justice. Important, and I'll come back to this in a moment, at 45, Lord Reid emphasising that second line of paragraph 45, restitution isn't a compensatory remedy in the normal way of damages claims. And then, importantly, we have the heading direct and indirect provision of a benefit, paragraphs 46 and onwards. And then Lord Reid essentially accepts that there are circumstances where it says in terms at 47, there are, however, situations in which the parties have not dealt directly with one another or with one another's property, but in which the claimant has nevertheless received a benefit from the claimant and the claimant has incurred a loss through the provision of that benefit. So, I mean, that's a reflection of the complex nature of transactions and so forth. We see it in some of the commercial cases that are referred to in this judgment. So there's no shutting out of an indirect provision. And then he talks about agency. You'll see at paragraph 48, and over the page, the Equiscorp case stands in the shoes, party standing in the shoes of the assignor, and so on. And then he draws that all together at paragraph 50. It has often been suggested that as a general rule, possibly subject to exceptions, that the claimant must have directly provided a benefit to the defendant. The situations discussed in the two preceding paragraphs can be reconciled with such a rule if it is understood as encompassing a number of situations which, for the purpose of the rule, the law treats as equivalent. The number of situations which the law treats as equivalent to a direct transfer. And we're saying that we fall into those categories. And we say it's a principled position, given the particular circumstances of this case. A parent standing in the shoes of the child, which of course is a common feature of English law, but also that it chimes with the personal injury law, the way it's developed with respect to gratuitous care. And the court will have seen how we put that at the instigation of Lord Justice Dingerman's particular focus on the Hunt and Severs, the judgment of the House of Lords in the Hunt and Severs case, 1994 case. We've got that in the bundle at tab 5. Lord Bridges' judgment in that case. The court will have had it.
Those cases are a bit different, aren't they? Because
well, of course
in those cases, it is the claimant's claim for damages for tort.
Yes,
so
yes.
You're in private law.
Yes.
And the claimant is saying these are damages to put me in the position I otherwise would have been in, and it's the claimant's claim because the claimant has a moral obligation to the parents. So the shape of those cases is very different.
Of course, it's different. Of course, it's different. But it's a different remedy. But as Lord Reid said, the law of obligations straddles tort and unjust enrichment, and he's also at pains to say that there shouldn't be a sloppiness of thought. The phrase we just looked at. Any development of the law of restitution or even application of the law of restitution must be on a principled basis, and the point I'm sure Lord Justice Dingerman's had in mind when he raised this, and we concur, is that English law recognises that there can be compensation for gratuitous care, and it's analogous to the present situation where care has been provided by parents on behalf of their child. And indeed, a lot of the PI, the catastrophic injury cases, are not dissimilar. I think in Hunt and Severs it was the tortfeasor who eventually married the injured party. But that's by the by. So we say that we're at one with the law generally and the principles of restitution as set out by Lord Reed. There is no magic template because it's a developing law and a difficult law because of the nature of financial transactions. I think the ITC, if the ITC case shows us nothing else, it's that. So back to our present case. It's been suggested that this indeed is a restitution case, and it follows on from my lady's comments, and it's suggested that CP was a claim for compensation for breach of statutory duty. I always say that simply can't be the case. It was never put like that. That's the first thing. And secondly, as a matter of fundamental law, there is no provision for compensation for breach of statutory duty in these cases. That's a well-established law, made abundantly clear by the House of Lords in the Exton Bedfordshire case in 1995, I think it was. We've got that case in the bundle.
Do we need to go to it, or?
Well, I just made the point. I was just going to give the head note, and the head note as the most important point, as is well known. There is no good claim for breach of statutory duty, but by a public body, unless Parliament expressly says that there is, and that is has been the position since 1994 and hasn't changed since. Now, there's nothing to suggest that there's any statutory provision in this context, or indeed the similar context, same primary act, of course, the 2014 Act, in the CP case, and so it can't be compensation for breach of statutory duty. It just simply can't be, and that can't have been what the Court of Appeal was making the award for. Not only, of course, have we got three very experienced Lord Justices on that panel, we'd also got two extremely experienced public law silks who were presenting and defending the case, cross-appealing that case as well. It's inconceivable that a court of that weight, with that level of assistance, would have overlooked what is in effect a basic principle that frankly a law student would be aware of.
Is it possible to see a third possibility in that case? Because it isn't very clearly explained. The basis is when you get to the Court of Appeal, it's a little bit fuzzy. But it was just a case where it wasn't quite the same sort of care plan as we have here, was it? But that I think where the court ended up was saying that the plan in CP should have encompassed provision for this young woman, to go to the day centre.
Yes.
And that should have happened from whichever date it was, 2016. Yeah. And that if the care plan had said what it ought to have said, the funding would have been available under the care plan. So it was more like just a claim for money owing, not pursuant to statute. It was almost like a benefit claim, saying this is what ought to have been provided, and it wasn't provided.
Well, it wasn't. Elisha makes a couple of points there. It wasn't like a benefit claim in that sense, in that you wouldn't have any right to recompense for a benefit that wasn't paid. I mean, there was no statutory right.
Yeah, you can.
You can ask for it, certainly.
Yeah, you can say, I'm due this much money per week and you haven't paid me.
There's no statutory right. Of course you can, but there's no statutory right. No statutory right to it. You'd have to go through the ombudsman and all that route. Who might provide compensation of a fraction of what's owed, frankly. And that's what often happens in these sort of cases. Takes years and you get very little back. Sorry, I forget your ladyship's first point.
So have I. I shouldn't worry. Let's move on. I just think
it was the money that was paid. Yes, sorry. Yes,
CP is a difficult.
Yes.
For my part, it's quite a difficult case to read too much into.
Well, no, because there's basic privilege. Number one, it's a restitution case. I don't think there's any,
well, we've gone through that.
I don't think there could be any doubt about that. Because if it isn't restitution, it can't be compensation for anything else. There is no other compensatory mechanism in English law that could have been that compensation could have been paid for. Your Ladyship raises a good point about the distinction between CP and the present case, in that was a direct payment case, and it was much simpler to actually look across the ledger, if you like, and see that money should have gone into that onto that side of the equation. But there's nothing in CP that suggests that if it had been a direct provision case, and bear in mind most cases are direct provision, my clients had direct payments at some point. It's very, very difficult to organise a complex care plan for children like this one. So that had gone in and out. And it went back to the direct provision rather than direct payment. There's nothing in the CP case that suggests that if it had been a direct provision rather than a direct payment case, that the outcome would have been any different. In our submission, it's a total red herring, because the value of the service was the same either way. So, conscious of the time,
have your detailed skeleton
yes,
argument on this aspect of the case.
I'm just checking that I've gone over all the points that I wish to make.
Of course. Yes, please do.
Bear with me one moment.
Of course.
Yes, and I make point here that and again, it's picking up on Mrs. Whipple's point about the reasoning in the CP case. Now, it may be that there's no mention of unjust enrichment and all the necessary stepping stones to such a claim in that case, because Lord Justice hadn't thought it was, as he said, straightforward. It may be that the boxes were ticked, and there was no need for a detailed analysis. But he does say that it's straightforward when all's said and done. Yes, so a couple of points made against me. One thing, it's said that this issue wasn't before the judge. Well, it was before the judge, because the judgment of CP in the Court of Appeal was very much front and centre of our submissions, and particularly the point about the father paying for the child's, the daughter's care. It's not therefore a new point. It's said that there's no unjust element. Well, I think we've dealt with that.
Could you just...
sorry, my lord.
I'm sorry if I was slow in not picking it up. But could you just formulate in a sentence what is the nature of the unjust element on which you rely? If that's an answer to a question I hadn't asked yet.
No, I think it's the same. I think it's the same question. Oh well, apparently it was in our statement of facts and ground, also in our skeleton. If we'll just,
let's deal with Lord Justice.
Let's do it now. What's the unjust? Because you've broadened unjustness beyond unlawfulness. So you're making a new case on appeal, which you didn't make below, as you've explained. I'd just like to know precisely what the unjust element is on which you are asking us to found this claim for restitution.
Just bear with me one. Oh, in the High Court. Well, I'm doing. Sorry, that's.
I don't think you're going to find it the answer in the old papers, because it wasn't argued at first.
Well, I'm just going back. I'm just going back to have a look at the statement of facts and grounds. How we put it in the very first instance, my lady, which seems to Yes, page 198 of the core handbook. And we did plead it as unjustness, not unlawfulness, my lord. Does the court have paragraph 66 on page 198? Yep. So your lordship sees there that it wasn't pleaded on the basis of unlawfulness. It was pleaded on the basis of unjustness, which is what, of course, is the required test. Now that would necessarily apply to unlawfulness as well as the wider unjustness. But hopefully that is an answer to your lordship's question. And the court has the point that I think we've made on a number of occasions, that it's not asked to determine, if you're with us, you're not asked to determine any quantum of restitution. That should be sent back to the High Court for further consideration. It may be that given the failure to, or the lack of any analysis of unjustness, and that's into criticism of the judgment, because it didn't arise, but because of the way the case proceeded, that issue would also be appropriate for further consideration. It may be, but that of course is a matter for the court. In any event, I noticed the time. I said I'd try and be half an hour. I'd invite the court.
You said quarter of an hour.
Did I say quarter of an hour? Sorry, my lady. But you have our submission.
Been on his starting blocks for a quarter of an hour. Yeah.
We'd invite the court to allow our appeal, dismiss the respondent's cross appeal, and find for us on the notice to I don't know if there's anything else I can assist any members of the court with.
No, nothing at the moment. Thank you very much indeed, Mr. Wise. Yes, Mr. Wilson.
My ladies, my lord, thank you. I'll start, if I may, just by replying to the points that Mr. Wise made. There's always a danger when one does that one ends up making submissions on everything in expanding on the reply, but then go into the specific points separately, I hope. So I'll try and be very brief with the reply points. Mr. Wise based his submissions on the care plan very much on the guidance which is in the bundle. That guidance is about the creation of education, health and care plans. That is a statutory document. There is a system for creating, they're set out in regulations, creating those documents subject to the guidance. You can then appeal them to a statutory tribunal. You can appeal with leave from that statutory tribunal. That there isn't any basis to take over that guidance about that system through to producing a document which is referred to in one of those documents. Certainly one hasn't been set out, it's just been asserted that you would take the guidance about the education, health and care plan and apply it to a plan referred to in that document. And you might have, whether it's good practice or not, doesn't matter, you might have many documents referred to in one of those plans, and on the basis of what's being said, they would all have to comply with guidance about a particular document. I'm not aware of an authority which says that that's the case, and one isn't before us. And I'd invite the court not to conclude that any document produced pursuant to an education, health and care plan is subject to the guidance in the document about how you produce an education, health and care plan itself.
There were two aspects that we looked at. One was, and I'd invite your submissions on it. One was the timing of review. I think there was a suggestion that a review had to take place within a year. And so are you saying that's just on the EAC? That's on the top level plan. It's not every single document within it. Is that your submission?
Yes. There is, and there is, if I may just very briefly, there are regulations which deal with this process is heavily regulated. It's one of those ones randomly stuck in my mind. It's 1530 of 2014 is the regulation. And that also picks up on the point made about how long one has to follow up on orders. It isn't to follow up on anything arising out of a tribunal. The tribunal makes orders and one has different time periods to implement those orders depending on the nature of the order. 5 weeks is a very common one, but that's for implementing orders of the tribunal. This court may decide, and perhaps the starting point is what Mr. Justice MacDonald decided was the appropriate time period, but it won't in my submission be found in those regulations. I'm sorry, my lady, in the other point, I apologise.
In the regulations that we looked at this morning, and the guidance, or you're on the different.
There are regulations as well as that guidance. So there's the 2014 Act. Mr. Wise said it's the same Act as in CP. It isn't. There are two 2014 Acts. There's the Care Act 2014, which is the CP case, and there's the Children and Families Act 2014, which is the Education, Health and Care Plan statute. Under that statute, there are regulations. 1530 of 2014 sets out a detailed regulatory scheme for producing education, health and care plans, and that is supplemented by guidance. Which we see the length of that guidance from the fact you have just chapter 9 of that guidance.
So I wanted to ask you, and I hope my head is not spinning too much with a bit too much detail.
Yes.
But what we were taken to in that guidance, and I'm in the authorities bundle, and I've marked up 2 passages. One at page 601, paragraph 9.69 we were taken to. And that was the point about setting out details within the EHC plan. And then, so that's on page 601.
Yes.
And then the bit that I'd flagged after that, specific to Appendix G,
yes,
was at page 604.
Yes.
And that's provision should be detailed and specific, and that's related to G. But so I'm going a little bit out of order. I'm sorry. The other part that I've now managed to lose, but somewhere there was a note saying you have to review within a year. The review should take place annually. I managed to lose that.
Yes.
Everybody else got that.
And that's a review of the education, health.
Yeah, sorry, that was in 9.69. So sorry, of the EHC. So that's what we might call the umbrella, the top level plan.
Yes,
okay.
That's right. And this table, my lady, beginning at 601, sets out each part of an EHC plan, and we can go if you wish. But if one looks at the EHC plan, one will see it is organised A, B, C, D, E, etc. So it follows this layout, and the process is you start with the child's and the parent's wishes and feelings in A, and then educational needs, right way around, health needs, social care needs, educational provision, health provision, social care provision, placement, etc. So you go through, and that is laid out in this guidance. That's what the A, B, C, D, E, F, and G, etc. is in this document. The requirement to review, so I haven't looked it up just before coming in here. I am sure is a hard word. I strongly believe that it is set out in the SI that I've just referred to as a requirement to review every year an education, health and care plan for and there is indeed an annual review, and you serve a notice of an annual review. I think it's regulation 15 actually, but
it's actually set out there. You can read it out. It's not controversial. Paragraph 42 just says which regulation it is. Regulation 12.
this is the one which talks about the time period, where the FTT requires a local authority to take action, and where the required action is to amend the special educational provision, in other words, to amend section F. That should be done within 5 weeks.
That's F, not G.
Yes. But I'm not. It may well apply to G.
May be the same.
But whatever it is, there is a regulation which sets out a time period, and that time period, and my submission, I think very much take on board the point about detail. My submission is that this guidance and the regulation to which I've referred are about education, health and care plans, not about documents produced under them. Now, it's a matter for this court, one could make the submission and say, well, that should be adopted as the approach to the underlying plan or to the plan referred to every plan referred to in an EHC plan but
now, where does this go? Because it was your client's evidence that there was no up-to-date care plan for this child. The last one was dated June 2023, and because his needs had changed, it was not clinically safe to be operating on the basis of that care plan.
Well, I'm not sure it said that. I'm not sure it said because his needs had changed, but
yes, it is. Paragraph 176 of Ms. Collins' witness statement, page 187 of the supplementary bundle.
My Lord, if it's the case that, and as Mr. Wise says, that the care plan that was presented in August couldn't be completed because further evidence and information was needed to complete it, then it's surely follows by imperative reasoning that it couldn't have been completed in any event at that point, which would be, in fact, another reason for saying that my client wasn't in breach, because it wasn't possible at that time to produce a document. Can I just continue with as quickly as I can with the responses to Mr. Wise's submissions, and then go back more generally to mine? Because the next point is to pick up on the care plan. There is, as I say, the point that if the one in August 2024 was, Mr. Wise says, not sufficient because it was waiting on other documents, then how could any other plan have been produced? And of course, that was the only plan, as far as I'm aware, that anyone was working to. So its sufficiency or insufficiency would apply to whoever it was who was delivering care. The other thing is, of course, that some of the defaults Mr. Wise alleged in that care plan, whether or not it should be nurses or carers and the number of hours, are not matters which are determined or litigated through care plans. And a care plan isn't a way to pursue a debate about whether or not care should be provided by nurses, how many hours there should be. And there are ways to deal with those things. The decision is made by way of the decision support tool. This is a non-statutory scheme, unlike adult continuing healthcare. Children's continuing care is non-statutory, comes with guidance, the national framework. Under the national framework, there's a document called the decision support tool. You have the decision support tool for A in the bundle, and it's at the supplementary bundle, paragraph page 3.
Page
3. And that's a detailed process, as you can see, over many pages of going through each care domain and assessing what the person's needs are under that care domain. And you can see on page 43, so obviously after 40 pages of assessment and analysis, you then have a recommendation. I don't, unless you ask me to, propose to take you through it, just to show you that that process is followed, and it produces a recommendation. The recommendation then goes to a panel. You can see the panel decision letter on page 45. And you can see on page 45 at the bottom, you can see that standardised assessment tools are used to try to ensure fairness between individuals. And the standardised assessment tool came up with a number, and then that was peer reviewed, and that came up with a number. So I don't propose to go through the numbers. If you go over the page, you can then see the panel's strong recommendation that the care is used for nighttime provision. And then they increase the hours. Mm-hmm. First of all, they round them up to 63 and then they double them.
Yep.
And that happens, and then there's social care and education on top of those hours. And that happens, that doubling happens, that number of hours. There was some discussion about whether care is two-handed or not. So that had been decided that there should be one carer with an assistant available in June 2023, before the later processes we were talking about earlier today. At the time that the first care plan was being drawn up, and the care plan, Mr. Wise said, oh, the care plan doesn't say whether or not it's a nurse, it doesn't say the number of hours. The care plan isn't a way to get outside of the DST system, which contains a number of ways of assessing need and provision, including peer review, standardised assessment and a panel decision, in order to ensure fairness between members of the community. And you can't then go behind that, but with a debate through the care plan in our submission.
What do you do if you don't like this then? You go to the tribunal, do you?
There is a process, there are a number of things you can do. You can go to the tribunal. This case did go to the tribunal. The tribunal suggested a higher number of hours and carers. The process for health
non-binding
is that it's not binding, and carers are being used, and in any event the number of hours have been increased, and the recommended increase in the number of hours wasn't accepted. There is of course a process of challenging that further if one wishes to. So I mean, that's one way, perhaps the easier way. There is, of course, judicial review, and you can say, well, that's difficult, but here we are. So it wasn't challenged; it was put in place. But in any event, that's the way to deal with that. There was a sort of implication, and one understands. I don't want to overly make the point, but I think it's worth responding to that. Perhaps the appellant was particularly interested in reaching a conclusion. It's, I think, fair to say, looking back through Mr. Justice MacDonald's decision, that the ICB has made great efforts, and I think my lady picked up on that aspect of the decision, great efforts to put in place provision, which includes offering new agencies reach in January 2024, Nursing Direct in July 2024, and Pulse and Coil in November 2024. There was, Mr. Wise referred to a witness statement about who was paying and said that A was paying or might pay, I think might pay. Obviously, that wasn't what was before the judge below, and we would invite you actually not to admit that in evidence in terms of the tests about whether or not the trying to avoid using the word believable, but the evidence is contradictory to the evidence that was put below, which was that there was a contractual liability for A's mother. I think it was put. We can look at it in certain sums. Wasn't suggest. I think it's fair to say it wasn't suggested to the judge that A himself was liable, and that must be the basis of the judge's finding. And then
I don't think Mr. Wise was saying he was liable. He was saying that some of his savings would be utilised, which I think is slightly different.
Yes, but I don't think it said that
A has the capacity to make a contract.
No, of course not.
Yes, and I don't think it said that was put to the judge either.
Right. Well, I certainly didn't pick up any suggestion that money of A's was going to be used.
Not in the court below.
No.
We were showing that he has, what was it, £31,000 worth of savings, which the parents had decided to use for his care.
And we can, we have taken the point in our skeleton argument that one can't, partly, of course, because Mr. Justice MacDonald referred to it in refusing permission to appeal, seems to us proper for us then to put the point before this court, which is that it wasn't put to him that there was a basis for making an alternative order. And of course, if it's based on a change of evidence, that would be a further reason for not allowing that to be pursued on appeal. And then, and if Mr. Wise's submissions on the law on unjust enrichment rather presumed that he had to show that the liability was not, that the payment was not A's, at the expense of was not A's, but that the claim could be brought by A's mother. I mean, this is one of those cases where clearly proceedings below would have been different had the case been put differently, which is the point on where the new the point in the cases on whether new points can be argued on appeal. And my final reply, if I may, is just my lord asked about what the species of unjust enrichment is, and it was said that it's being unjust. There are, of course, recognised species of injustice for the purposes of unjust enrichment, mistake, duress, ultra vires, etc. And in our submission, one can't cast a new species, at least in this way. You can have incremental changes in the law, but one can't simply say that unlawfulness isn't required. You are basically asking the court to make its, which of course is said in investment trust companies shouldn't happen, to make its own assessment of the justice of the situation. And what the claimant appellant needs to do is get within a recognised species of an unjust factor, or explain in quite tight terms why there should be a new species created.
Well, there's that point, but also the essential answer to my question, I think, was that the parents had no choice but to ensure that care by in vivo continued. No doubt put a bit more eloquently than that in the statement of facts and grounds, but your answer on the law may be that's not a recognised species of unjustness, but on the facts, presumably you say, well, they did have a choice. May have been a very difficult choice for them, but they made it.
Well, we say that, of course, one of the people who was available to make provision was a nurse, which is the provision that one would get if one was in hospital. But we would also say, of course, that point was run and not accepted by Mr. Justice MacDonald, who had to, I think it's paragraph 90 of the judgment, who had to look at, as so often in these cases, a number of factors and balance them against each other. Yeah. I am satisfied the defendant's decision on the 9th of July to terminate in vivus contact and to arrange for nursing direct to provide the healthcare provision specified in section G of the EHC plan was a decision within the range of reasonable decisions. So Mr. Justice MacDonald finds both of those, that those factors were reasonable. And it is our submission that where there is an express finding, there isn't then a basis to go on and say that it would be unjust not to require a payment to be made for other provision. In other words, there isn't a causal nexus. Mr. Justice MacDonald's decision is a good example of, I think it's Lord Stein in Daly, aphorism that in law context is everything. And the judge stresses that in his decision. And you can see a useful summary in paragraph 29
of the judgment.
Of the judgment, my lady, yes. Which is page 51 of the core bundle.
What do you want us to take from
Yes.
paragraph 29?
So you can see multiple factors. Multiple factors are stacking up at this point. You have an unregistered company providing almost all of the care. You have lengthy attempts by the ICB to put in place a registered provider, starting with naming one in January. Considerable delays in getting appointments made, and then a provider refusing to work with that new named provider to train them. The ICB experiencing an incident with another unregistered provider in November and taking the learning that it had to do something about that and taking months in order to do something about it. And this is only May. And I take that you have in my skeleton argument, I've set out a range of factors over those months. But that is a summary of the multiple factors coming together, which is only in May. And there continues to be another 2 months during which consent for REACH, the organisation named in January, consent for them to proceed is withdrawn. So then Nursing Direct is proffered, and again, there isn't agreement to proceed with them. And that context is a crucial one to the decision that Mr. Justice MacDonald had to take. And that's why those are the factors that had to be balanced by the trial court. I have summarised them. Obviously, we went into them in considerably more detail and to the underlying evidence reflecting them. And that, my submission, is the basis of the decision that I took you to in paragraph 90, that it was a reasonable decision. Indeed, the judge says that the ICB could not stand back and do nothing. So the ICB was bound to act, which shouldn't be surprising given the panoply of factors that I have set out. My lady, I can, if I need to, if it would help, I can go through that background in more detail. Thank you.
It's very fully set out by the judge. I mean, it's a,
yes.
You know, it's a
yes.
pretty
I mean, one can understand, and it would in any case, of course it is. He says he had a heightened standard of review. He set out the factual situation fully, would weigh on anybody. One understands all of those things. But there came a point at which there had to be a change to a different provider.
And that ends up with the finding he made in respect to which Commission to Appeal was refused. So
yes,
that's the backdrop.
Yes.
Against we must work.
Yes.
Against which we must work.
So what I propose then to do is to look at the question of at the expense of, which was a lot of the last part of Mr. Wise's submissions. Briefly at the point about unjust factor, and then at the care plan, to take it in that order, if that's helpful.
Whatever works for you.
Yes. So at the expense of, I'll give you the references. The second statement of the appellant's mother. So I'll say, as I've said below, when one naturally talks about people in slightly oblique ways when trying to respect a confidentiality order and possibly live stream. So I don't not use names out of disrespect. I'm trying to respect people's privacy.
The family will understand that also.
And the evidence there was that there was I think I should get it because
Where are we?
I just want to get the right word. It's supplementary bundle 215, paragraph 14. Yeah. I have accrued a debt of approximately £80,000. So, one can also see, Mr. Wise very fairly recognised the challenges of managing a package that there were still in paragraph 12, £90,000 from when there was a direct payment being made here, which hadn't yet been dealt with through drawing up accounts. That was there, but the claimant's mother had a debt of £80,000. By November, on the supplementary bundle, page 250, the cost of the care, I think Mr. Wise took us to this, was £186,000. So rather more than the budget the ICB had estimated when it made its decision of £150,000 per year.
Sorry, where's the 186? I can see 198.
Very last line of the page.
So the ICB budget was 150,000 as the care package, was it?
That's
we saw that in the first document you took us to.
That's the figure in the letter, the decision letter.
Yeah, thank you.
So there are three aspects to the question about the expense of. There is the investment trust company's point, there is the CP point, and there is the Hunt and Severs point. Investment trust companies of that case, looking at the two questions really before the court: the statutory time limit on the right to bring the claim, and the question about whether the distinction between whether any loss would include the input costs of the company which paid the VAT, so it deducted those from the VAT that it paid, and then of course whether there was any claim at all for the people who purchased the services. And the decision of the Supreme Court was no, there wasn't a claim for the people who purchased the services, because you couldn't collapse the two contracts one into the other. The obligation to pay for the services plus VAT and the obligation to account for the VAT were not the same transaction or sufficiently closely related that you could say there was a transfer of value from the customer to the Inland Revenue Commissioners. And that is paragraph 33, it's at 335 of the authorities bundle of ITC. And that leads on to the court discussing it in the general discussion from paragraph 37. The question in each case is whether there is a sufficient causal connection in the sense of a sufficient nexus or link between the loss to the bank and the benefit received by the defendant. And saying that saying at 38, 39 that there needs to be a rule about this. And at 45, giving preferred terms of a diminution in the claimant's wealth or simply a transfer of value. And interestingly, the example is given in relation to the provision of services in 45 when raising the question about transfers of value. And the example given about 5 lines up from the bottom is the loss to the claimant may be incurred through the gratuitous provision of services, which would otherwise have been provided for reward. So that is drawing the focus onto the person providing the services. And of course shows a distinction with the position in Hunt and Severs, where that person wouldn't have a claim. and shows that the person providing the services, and shows that the view of the Supreme Court is that person would have potentially, subject to finding of all the other elements, of course, potentially would have the claim, and that would be where the transfer of any value lay. Having said that, you then get the point that from the Supreme Court that the benefit needs to be direct, subject to exceptions which it lists. And as I understand it, it isn't said any of those exceptions applies here, but a new exception should be created. It's accepted, I think, by implication of that the parties here haven't dealt with each other directly. And it isn't being said that one of the examples given by Lord Reed applies to the transaction which took place here, on my understanding of the way the case is put. And my final point on that case is that it all suggests, as do all the cases in this area, that the correct claimant is the person providing the care, not the person receiving it. And that, of course, is the claimant in the Surrey case. It is the claimant in the Canadian case of Skabinski that is quoted in Surrey. And it's the implication of, as I say, that passage that I took you to in investment trust companies. So in our submission, taking investment trust companies, there isn't a transfer of value. Is there a basis to say otherwise in CP? And my lady has said a lot of emphasis is put on that. Not in our submission. Mr. Wise puts a lot of emphasis on the High Court, where, of course, the claim failed in the High Court. The claim failed, and the judge said that there were no authorities put to him under which it could succeed. And if we look at the High Court decision, it begins at 418, 418 of the authorities bundle. Mr. Wise took you, I think, to paragraph 59 on 435. If I could just take you back to that. He took you to the last part of that paragraph. But the first part of that paragraph shows that also before the court were claims in relation to direct payments, personal budgets and direct payments in relation to April 2016 to August 2017. And then at the bottom of paragraph 60, if unlawfulness is established, 3 or 4 lines up from the bottom, there will be a concomitant additional direct payments, effectively arrears, on the basis that the claimant and her parents have been out of pocket required to make the shortfall in the care services. But you can see additional direct payments. So the case is put in not, Mr. Wise says it could only be this because that's the only way it was put. But it's not the only way that it's put. And then 66, Mr. Lawson maintains his challenge to the 2016 and 2017 assessments, addressing first of all the unlawfulness of the personal budgets. Now that claim lost. You can see on page 442 in paragraph 94. The duty is a clear one, derived from section 26 of the Care Act 2014, and we'll see that in the Court of Appeal judgment in a moment. Failure to provide a transparent budget in a care and support plan represents a prima facie breach of that duty, which would be susceptible to challenge by way of judicial review. And then 3 lines down, the claimant provides a compelling argument in respect of the earlier plans which were defective in providing this transparency. Paragraph 95, however, in my judgment, the submission of Mr. Locke in this regard is a valid one. The earlier care and support plans have been superseded by the later plan. So there's a challenge to the earlier plan, but the claim fails because those plans have gone. And that, of course, is where you saw the Court of Appeal saying that was heterodox. Point being, well, there's a challenge to it. The fact that it doesn't affect the future doesn't mean that one can just, on that basis, put it aside. So that's the challenge in the High Court. We then go to paragraphs 113 and 114.
What page?
Page 448. And the claimant loses there too. And loses for different reasons, but loses there too. That goes to the Court of Appeal. I mean, my first submission would be that generally one would interpret the Court of Appeal decision on its own terms, but because you've been taken to the High Court decision, it seemed sensible to go back to it. And you can see then within the headnote, first of all,
Moving on to the Court of Appeal now.
Moving on to the Court of Appeal, I'm at page 487 of the authorities bundle. It's by D, just above D. The personal, we'll see it actually in the judgment, but the personal budget was fundamental to the operation of the care and support scheme under the Act, providing the mechanism by which the service user was to exercise greater choice and control. So you can see that the law reporter considers that section 26 is important to the decision in the case. And then, forgive me if we go through, because you've been taken to this and a lot of emphasis is put on it, I'll go through the case more slowly than I usually would. Paragraph 6 on page 491. You can see that, first of all, there is the reference then to a personal budget being set. That's the history of the matter. Paragraph 8, the bottom of the same page, you can see a continuing healthcare checklist was completed. And then...
Might be relevant to note on page 490 that the grounds of appeal, I appreciate it's only a summary, number 3 is the judge had been wrong to conclude that the claimant was not entitled to be compensated, which is more the language of damages than restitution, though obviously one doesn't know quite how it was developed in a skeleton argument.
Yes, I was going to go to that in the judgment. Let's so one can then see paragraph 8 on 492. Again, you get the personal budget set out. And you can see the reference in paragraph 10 that XYZ was a charity organised by CP's father. The Court of Appeal later says no reason to doubt that. And you can see then on 494 judicial review proceedings are issued, top of the page, number 1, a failure to calculate a personal budget which was transparent as required by the Care Act, and then number 2, insufficiency of the amount. And you can see, well, that claim is issued in July 2016, and you can see that is 3 months after a direct payment was set on the 11th of April in paragraph 17. And of course, 11th of April is the date given later by the Court of Appeal for when they would make their order. So you have a personal budget 11th of April, 3 months later a judicial review. And then the claim is summarised by Lord Justice Haddon Cave at 495, paragraph 29. And you can see both paragraph 2 deals with personal budget and direct payment, that it was inadequate. And you can see at the bottom of that page it was also clear that restitution was an issue in the High Court because it's set out at paragraph 5, the very, very end of paragraph 29 on page 495. And section 26 of the Care Act, I said we would come to, it's paragraph 39 on page 497. And you can see at the end of the first paragraph, if on that basis the local authority itself must pay towards that cost the amount which it must pay. You can see there was a personal budget. So the difference is this. There is here a statutory right to receive payments. Parliament has provided for money to move from state to citizen. And that isn't an issue in today's case. And that, of course, then is consistent with, it offers us always the best answer, it offers the simplest explanation for CP, and it's also consistent with Lord Justice Haddon Cave ending by saying, well, there's no private law claim here. So, sort of, what's the motor here? Well, that. And then the issues are summarised. The court repeats again the issues in the judgment below at paragraph 50 on 501. I won't go through them again, but again it refers to restitution having been in the court below. And then the issues on the appeal are at paragraph 53. And my Lord, I was just comparing that to the summary given earlier in the judgment. So you can see the first one is, was the court right in paragraph 95 in holding that the fact that there's been a change of position obviates a possible claim, poorly phrased. That was the first ground of appeal, and that's the basis of my submission of Lord Justice Haddon Cave's heterodox statement. A particular point about whether an appeal to the FTT stopped a judicial review is the second issue. And the end of that second issue is the legality of its alleged failures under the Care Act. So what that ground of appeal is saying, no, you can still look at the legality of the Care Act decisions, even though there's an FTT appeal. And then issue 3 is put as what relief should be granted. And then you have the two cross-appeal issues. And then 56, the court unpacks what issue 2 is. The council's case was placement at XYZ with social care, and it did not include placement cost in those plans. CP was granted permission for judicial review to challenge the legality of those care plans. So, again, we say there's a string running through this showing us what the decision is, which isn't, my lady, to say that it's easy, but just to say that there's a string we can follow through it. And then ending at the last part of that paragraph, by stating as a submission that the court should have determined the legality of the Care Act 2014 plans, starting with the 2016 plan first challenged. So again, tying it back to the judicial review being issued and what it's issued about. And then issue 3, the court should allow the appeal, declare that the earlier plans are unlawful, quash and order a redetermination of those plans. And that, of course, again gives you a route to recovery, which is separate from private law. So that's the context, that's the field in which the case was being determined. And we then see the determination of it, paragraph 75. In my view, the basic statutory position is clear. The Council's failure when drawing up CP's support plan dated 11 April 2016 to ensure that CP's personal budget included an adequate payment for her needs, including her weekly attendance at XYZ, represented a failure by the Council ab initio to comply with its statutory duties under Section 26 of the Care Act, which is a section that provides for personal budgets and an amount of money to be paid to be set. And then you can see that follows through paragraph 78. The judge correctly held the central question was whether payment for attendance should have been provided in CP's Care Act personal budget. '79, the judge correctly held that the Council's failure to ensure CP's personal budget included a payment for XYZ represented a failure to comply with Section 26. 81, at Power 94, he found the Council in prima facie breach of its duty under Section 26 of the Care Act 2014. And the same we then go on to '83, my lady, that's the move to a slightly more general statement. Needs to be interpreted in the light of everything else that we've looked at, and also in the light of the concluding statement in the decision, that it's actually paragraph 89. I'm sorry, that there is no private law right engaged, and it can't be unjust enrichment if there's no private law right engaged. But it also isn't breach of statutory duty in the Exon Bedfordshire sense, because it is looking at a provision in statute which provides for the payment of money. In other words, my lady, it's analogous to a benefit case.
Well, that appears very clearly from the final sentence of the judgment, doesn't it? Because the analysis is that CP has an accrued right to be paid the cost of her attendance. Now, that may be right or wrong, and obviously it's binding for what was decided in this case, but it's not this case.
Indeed.
It's not our case.
No. That's our submission, and it's been a controversial one, but in our submission there isn't a way of carving out of this case a finding of principle that there is a restitutionary claim. I mean, that, for the reasons that I won't repeat. It's also not right that it offers a way of dealing with the point about who's the correct party, because the Court of Appeal in a way is expressly disagreeing with that submission and saying, no, this is a claim by someone who's claiming money to which they're entitled, and if they use it to pay for this placement, which is run by a charity founded and controlled by her father, that isn't a conflict of interest with the litigation friend. So in our submission, this case doesn't help on either point. I'm sorry to go through it more slowly than I would have done, but
no, it's been central to the case, and
yes.
So it's helpful to have heard it in detail from both sides.
That takes us on to gratuitous care. You have our points really in the skeleton argument. We say it's a different.
Just tell us the paragraph numbers, would you, Mr. Morrissey?
Paragraph 45 onwards.
Thank you.
I mean, we start with first principle, simply the point that in one case, someone has been caused loss. They have, contrary to some tortious provision or in a way that generates tortious liability, they have been caused loss by another person, and the question is assessing the value of that loss. And that is a different question from the question in unjust enrichment, where one is looking at a transfer of value. The law of unjust enrichment is perhaps asking a two-part question, which is, does the claimant have a diminution in the value of their wealth, as it's put in one case, and is the defendant's gain at the expense of that diminution? And so it's actually a very different set of questions from the question about whether someone has suffered an injury and the valuation of that injury. First of all, the question about gratuitous care simply doesn't go to that second part of the question of is the gain at the expense of the loss or to any sort of causal nexus. So that's looking at it from that way round. And you can see there are a number of things in the cases which show, if we just look at two, if we make 20G in the authorities bundle.
Sorry, tab.
Page 20. This is in Donnelly. I mean, really, this is, I suppose, just an expression of the point we've just seen made generally, which is what is the task the court faces in a tortious claim. And one can see at G, it is because of the defendant's negligence that the plaintiff needed to find board and lodging. Just as in the present case, it was because of the defendant's negligence the infant plaintiff needed nursing. There isn't really a corollary to that in this situation. And then one can also see the other part of the rationale for the Donnelly and Hunt and Severs case on 31F. The point that the voluntary carer has no cause of action. And what can we say if we stand back and we look at those two cases? Any principles we can draw out? In those cases, there's an established right for the person to be compensated, whereas, of course, in unjust enrichment, you're looking for whether there is such a right. The question gratuitous care goes to is quantum, whereas here, in unjust enrichment, value is part of the cause of action. So for those we would say are just reasons or principle why there isn't a basis to read across from one of those situations to another. And it would appear that under the claimant's argument, the appellant's argument, the service user in Surrey would have had a claim. And that can't be right. Surrey is a case where Surrey County Council brought a claim against Lincolnshire Clinical Commissioning Group and obtained restitution, obtained an order. But if one applies the gratuitous care cases, then the loss or the transfer of value could have come from the service user in that situation, and that can't be right. That takes us on to our notice to affirm, and the point that there's no unjust factor. And that is related, of course, to the point that there's no causal link. The simplest way that could be put is to say, well, ground 2 failed, and therefore there isn't a basis to go forward. We have in the bundle the Surrey case. I'm going briefly to show it to you. It's 537. I don't propose to go through it and analyse either how they dealt with, unless invited, either how they dealt with transfer of value, claimant's expense, or unjust factor, but just to give some headlines. So that is a case in which a local authority, Surrey County Council, provided Care Act funding for someone where a CCG refused to assess them and refused to offer them any services. And it was held that they were likely to have found that the person was entitled to services had they assessed them. And the claim was brought by the body which paid against the body which didn't pay. And these, in broad terms, the species of unlawfulness relied upon was ultra vires, was that the payments were ultra vires, and it drew that out of the Woolwich case and the Auckland Harbour Board case and the Deutsche Morgan Grenfell case. So it's an example of going to particular decisions, finding species of unjustness, and it's then applying those to the facts to see if they applied. And it's between two public bodies, and the Deutsche Morgan Grenfell case is about whether tax payments are unlawful in certain circumstances. So there isn't anything akin here in terms of identifying an unjust factor. And we've made two. I'm ready to go through that case if it would help, but I think it might just be an exposition of the law of unjust enrichment. So I'll leave it for the moment. But so we take two things out of the invitation of the appellant to go much broader, and to say that you don't need even to have unlawfulness, but the court itself can identify something as being unjust on the basis of its perception of the circumstances. So two things would follow from that. First of all, that would be effectively a decision contrary to or very significantly undermining the Exham Bedfordshire, O'Rourke, Clunis chain of authorities. And the way we put it is this. If one thinks about O'Rourke, that is a case where someone left prison, homeless, priority need, and they weren't provided with housing by the local authority, and it was said they couldn't bring a damages claim. But first of all, there was unlawfulness established. So the claimant appellant here is in a more difficult position than the person in O'Rourke, because they haven't got that in a relevant way. But if you then say that that person in O'Rourke could have brought a claim in restitution, you are in fact giving if they'd gone off and bought housing for themselves on the private market, if they could then have claimed that rent back from the state, other than through the housing benefit system, but claimed it back through an alleged breach of the homelessness duties, you would effectively be creating, for the people with the social or financial capital to do so, you would be creating a carve-out of Exham Bedfordshire for people in that situation in respect of certain loss. So that's our first point. And the second point is this: if you take the submissions to their greatest extent, one risks effectively creating a sort of voucher system for state provision. There are very many procedural rules about decision-making in state provision, and if one says that any of them could be a foundation for a claim in restitution, you would be changing a lot of state provision into potential rights to a financial claim. And you could think, we've just talked about housing in O'Rourke. You could think about school admissions and parents who say there's been a breach of the school admissions system, so I'll purchase alternative provision. You could think about housing, education and social care, all of which could have generated a right to claim a payment for making provision for oneself, unless one can find whatever the species of, find some fact, and that of course is why, that's precisely why, in my submission, the investment trust companies says, well, we have to use these given signposts, we have to look at the learning of our forebears, where they have identified types of claim, and then we have to find what those types are and apply them, which is what they did in Surrey and in investment trust companies, because otherwise you end up simply with an expansive right to seek recompense for expenditure. Well, I think we have two things left. We have the cross appeal,
Yes.
and the appellant's notice to affirm. Before moving on to both, in a way, both of those subsidiary points, my lady made the point, well, to some extent, these points are secondary, belt and braces potentially. So before moving on to them, can I assist with what are, I think, clearly the primary points, that is the points which are in the notice of appeal and respondent's notice other than cross appeals? Is there anything further? As I say, I've tried not to simply go into restitution very generally, just to focus on points in issue.
No, I think you've covered what we need, I think.
So our cross appeal is but I hope very gentle, simply to say that there was a document of which the ICB became aware after the proceedings, which was relevant to the proceedings. We say that it should have been provided during the proceedings, and that it can be seen from the judgment that, and from the evidence, that it was in issue. There's been a number of objections to the way that's put. One of them by way of an application to set aside the permission to appeal, on which it was said that essentially that the point hadn't been put before the judge below. It's page 11 of the further supplementary bundle, paragraph 16. So there was a clear suggestion that the information was not known to the ICB or the judge in the High Court.
Moment. So this document is...
Further supplementary bundle, it's our response to the application to set aside the permission. And at paragraph, I apologise if it is, I don't think the application to set aside is in. Paragraph 16, page 11 of the further supplementary bundle, quotes, subsequently stating, line 3, the suggestion that neither the ICB nor the High Court knew that Inviva was working on revising the care plan was therefore wrong and materially misleading. And we explain at paragraph 20 of that document all the times in which, in fact, it was clearly before the court below and in our evidence that Inviva was working on revising the care plan. It's then said in the appellant's skeleton argument for these proceedings that it is misleading on the basis the ICB is saying it didn't have the document. But I think, as my lady has already picked up, the ICB isn't saying that, saying it wasn't aware of the document. And that is, the references to that are given in footnote 8 of our skeleton argument. But we have tried to put this as simply and kindly and moderately as we can. And Citizens UK is in the authorities bundle and is a case which very, very simply says, it's not quite the language of accidental, but inadvertently not providing a document nevertheless remains a breach. It's made for it's page 405, 404, 405, so forgive me for going to it, but I just want to use the correct words. 404, 405 of the authorities bundle, my lord. And it's at the top of 405, simply confirming it can be unintentionally. And we've used Citizens UK because it's one of the more low-key, keeping everything calm, authorities on the point. So we've just set that out. In terms of the admission of the care plan, we say that it satisfies the tests in 5211, which, as I understand, is actually now the basis, in fact, on which admission is dealt with the Ladder-Marshall tests often being used as the touchstone for applying the fairly open discretion in 5211. And all three of those tests are satisfied. Believability is not an issue. There's a good reason why it wasn't provided previously, and it probably would have had an important influence on the outcome of the case. And there's 5 that we've set out, but the additional point that actually, if, as was said in submissions today, it wasn't possible to draw up a care plan, the draft care plan couldn't be completed. It's not possibly a final care plan because it lacked certain material which wasn't available, which was being waited for, then that's a strong argument that the respondent ICB isn't in breach of duty. So
do you challenge the judge's? The judge said that seemed to say that you should, within a reasonable time after the November 2023 EHC, have looked again at your care plan. Do you challenge that proposition? I mean, you've taken us. You've said the timelines don't apply. It's not like there's a deadline or anything. So where does that leave us in terms of what the right legal framework is? What is the expectation on an ICB in these circumstances?
I mean, our argument to the judge was that there was a healthcare plan, that healthcare plan was at the date of the facts of the case within a year of being issued. The key changes had, for example, having 2 people had happened prior to the tribunal finding. The judge, my lady, I think said May, and I think I've given that reference in our skeleton argument, said, sort of put it negatively, and so I can't accept that May was good enough, so therefore one can see that May is therefore the long stop. Our submission is that once one sees what had then happened, that in fact there was work toward producing another document, and the test in the statute, in section 42, is arrange the provision. So the ICB was arranging the provision, that is the provision of a healthcare plan, and one can see the difficulties that producing such a document has and changing care providers produced in this case. And if one also sees that there wasn't, even despite all the effort of Enviva, that there still wasn't one by August, that not so much, my lady, that the time point in May was wrong, but that it reasonably wasn't possible to do more than had been done by having a document from June 2023, having people working on a change to that document in circumstances where the appellant says more was required. And if I may, just one thing in that care plan.
Remind me where it is.
It is. It's in the supplemental bundle, about page 129. Is the bit I want these to take us to. My understanding.
Hold on. So where are we? We're looking at the
August document, I believe.
Okay.
We've gone to it somewhere else, haven't we?
Will you just bear with me while I find it? I think it's in the further supplemental, which is where my marked up version is.
And I told it's also in 88 in the further supplemental bundle.
Got it. Yeah. Oops.
I'm checking my point is in both.
It's the same document.
Same document.
Yes.
Yes.
Okay. Okay, so this is the August care plan. Yep,
Yes.
draft.
And one of our submissions is that this is a very detailed 20-plus page document, and that it does set out a timetable. And you can see a day routine set out from on page 129. And that day routine within its own terms will depend a little bit on when things happen. For example, how long the appellant sleeps for.
Are you in the one that starts on page 88?
Yes, it's page. I'm sorry. Yes, so page 109 on the one that starts on page 88. Page 129 on the other.
Thank you very much.
On the other one.
Thank you.
But you can see at the bottom of that the underlined in bold, this routine is currently being updated according to school and will be added when finalised. So again, one of the challenges being taken is that there isn't a timetable for what's going to happen when, but actually there couldn't be a timetable. It was said by the appellant, those working with the appellant on drawing up the August document, there couldn't be a timetable. So that, again, would be a reason for finding that there wasn't a breach by the respondent in the ways put forward by the appellant of drawing up a plan. Because we've seen that the hours and the staffing is determined by the DST decision, and we've seen that there is a daily list of actions with some times, but it's said we can't go further than that. At the same time as it being said that the failure to have a better plan is unlawful.
So what is, I mean, in short terms, is your submission that you did all that you reasonably could in the context, and we've looked at some of those factors. Is that where it lands up, and that
Yes.
you say is why you're not in breach of duty?
Yes, and that's a submission we made to the judge and didn't get home on. We made the submission about the nature of arranging provision, which is what the statutory obligation is. The provision to arrange is a plan. Paragraph 65 on page 61 of the core bundle, for example.
So your submission is substitute or add a repeatedly requested and dated plan which failed to deliver, and then insert reference to the August plan. And your submission is that had the judge been aware of the August plan, he wouldn't have seen a deficit in the submission.
Yes, he would have concluded that the ICB had made reasonable efforts. Those efforts have been partially successful, and the limits on them didn't derive from the ICB, but derived from the circumstances. E.g., they were waiting for an education plan.
I think, forgive me, it's getting late in the afternoon, I might be losing it a bit. Is it your case that the judge just plain got it wrong on ground one, regardless of this new material, because on a proper analysis, you'd done everything that you could, but actually, further in any event, it's supported by the new documents, because even if you don't get home on version 1, then version 2 puts home that you've really done everything you could have done. I'm just trying to understand how the case stands.
I think it was our submission to the judge, and the judge rejected that submission. And our appeal against that is founded on the August document.
Yes, there had been no freestanding appeal.
Yes.
Against the judges,
yes.
ground one.
That's right. And so, yes, we had argued it, we'd lost it, and
you were living with it.
That. Yeah. And of course, this is brought as a cross appeal on the basis that we're going to be having an appeal in any event, even then, rather than as a freestanding appeal for.
Understood.
It was brought and dropped, and then brought as a cross appeal. And that takes us to the care plan points.
Now, the judge did not think he needed to make findings about that.
That's right. And there are 3 cases. I just want to respond to those 3 cases. It was A, B, and Nottingham, G, and
Mr. Wise on Mr. Wise.
Yes. Yeah. They're all cases under statutory schemes. They're all cases under schemes which are subject to extensive guidance. And they're all cases, we'll have a look to see, obviously, but which appear to have lamentable failings. And our submission is that can't possibly be said about the document which is in front of this court. 20+ side documents written by care agencies over months can't possibly be said to be self-evidently deficient, and that you would require evidence, factual or expert, to find that they were deficient. And to the extent you would require expert evidence about what should be in a plan, we would say under Law Society case that's an indicator that it isn't a matter for judicial review at all. So if we briefly have a look at the 3 cases you were taken to. A, B first. 206. There is a well-known statutory there's a well-known statutory basis for this section 17 of the Children Act, which is referred to paragraph 6, and at paragraph 9 that the court was taken to 4 pieces of statutory guidance. So subject to heavy guidance. And then for paragraph 23, the child protection plan probably drawn up soon afterwards. Calls under line 4 a multi-agency programme of activities including health, education and welfare which will divert him from criminal activity. And then the conclusions and recommendations are set out on page 214. Comment on difficulties setting boundaries, for example, in the second paragraph of the conclusions at the bottom of 214. And then 215, recommendations, updated education plan, close liaison between different bodies, accesses a particular project, and his mother is supported. And then one can see at 216, the claimants say that that is insufficient. And then 41 on page 217, drawing on the framework document, sets out what should be in a plan. And perhaps unsurprisingly, in the circumstances, so 41 setting out what should be in a plan. And then 42, third line, I cannot find in the documentation anything approaching an assessment capable of meeting those requirements. Child protection plan prepared and reviewed December 99 onwards was thin and left a great deal unresolved. So what we see is a document subject to its own system of guidance, leading to a very basic provision. It took 2.5 pages for Mr. Justice MacDonald to describe this care plan, leading to a very basic document which was found not to be sufficient. The same occurs in G in Nottingham, which is at 221 of the bundle. Judicial review proceedings about a pathway plan. That's a statutory document under the Children Act 1989 and particular regulations, the children leave and care regulations. And you can see the judge at paragraph 30 on page 231. So I'm actually going to take to 230 rather than rush through it. But 230, you can see the regulations require in terms that certain things are set out. And not just that they're set out, but details of this, details of that. And then over the page on 231, Mr. Justice Mumbers, who then was, refers to another of his decisions, the Caffili case. And you can see over the page, you go through the Caffili case, and then over the page on 232, you see the indented passage at paragraph 34. The bottom of the first paragraph is the aphorism that Mr. Weiser refers to, who does what, where, and when. And then the next paragraph, last 2 lines, nothing less is called for in a pathway plan. Indeed, the regulations, as we have seen, mandate a high level of detail. So it's a decision about a particular statutory scheme. We might say, look at an education, health and care plan. There are regulations, there's guidance, they call for it to be very specific. That's not what we're dealing with here. We're dealing with a plan for how to do something. And a how to do something plan is different from an assessment with a multi-agency plan of action. And then one can then see, again, what I said about the lamentable content, page 233, where you should explore the possibility of counselling. And over the page 234, discussion in terms of education, discussions before the end of the month. And then the judge says in the next paragraph, exploring things and discussing things is a lamentably inadequate care plan. But again, a very, very long way from our situation. And then finally, J and L. J and L, there's a child who used a wheelchair, lived in a bungalow, but the doors were not adapted or sufficiently wide. L, the child had a number of difficulties. 288, we'll go to it in a moment. A number of difficulties. Risk of drowning in the bath and the risk of being knocked over on a road nearby. The only way given to manage these risks was parental supervision. That's paragraph 59 Roman 1. Which is 312. And then over the page, but this in turn obscured what really needed to go in the plan at Roman 2 at the top of page 313, that if the family was not successful in getting alternative accommodation, the situation would need to be reappraised by social services. So the point here is it's actually not a finding about specificity and detail, but it's a finding about analysis and action, and that the challenges faced by the family have not been dealt with other than by a temporary process of constant parental supervision of the child at risk of being run over on the road, and that therefore some consideration was needed about what went beyond that, which isn't a point about who, what, why, when, timetables. You know, it's about an assessment of risk and what should be done. So again, standing back from that, those cases, repeat what I opened with, I apologise for doing that, but those cases are all about a statutory scheme with regulations and with guidance. They are essentially akin to the EHC plan in this case. They are not about plans of action or plans of service delivery. And this plan of action, plan of service delivery, is significantly related to healthcare, not only, but significantly related to healthcare, and is a matter where one can't simply make the sort of assessments made here, that saying you're going to have a meeting about education is a lamentable education plan. We can all see that. That's very different from saying how you're going to respond to someone desaturating. And that would require factual or expert evidence, probably expert evidence, isn't really properly before us today. There isn't a basis for those findings and probably isn't suitable for judicial review. Just before I summarise, may I just turn my back just for a moment?
Of course.
Thank you. So, end very briefly by emphasising really two things. The difficult context, which received careful and sustained attention from the judge, with inevitably a lot of focus on going through the statements and the evidence, reaching a conclusion where the factors concerning the ICB are very pressing ones about whether the actual provider is providing the care, the role of an unregistered provider, the difficulties of working to put other care into place. A very lengthy time taken to try to find a way forward from concerns that started being expressed by the appellant's mother in the autumn of 2023, with new providers being put forward at the beginning of 2024 and continuing right through the end of the winter, the spring and summer of 2024 to try to put in place alternative provision, reaching the conclusion, having consulted with the family and with the local authority, that action had to be taken. It was properly a matter for the judge to decide, and the conclusion was that the only basis of relevant unlawfulness put forward was rejected. And where there is an express finding that you can stop one provider and start another provider, there isn't then room to say that there is an unjust factor or any other basis for the organisation to provide recompense for someone not accepting a lawful provision of services. That is ultimately a matter subject to the courts for the organisation to decide it has the statutory underpinning is Section 3 of the NHS Act, which provides that ICBs will meet the reasonable requirements that people have for various forms of healthcare. And the ICB has done that according to the National Framework for Children's Continuing Care, applying that process where there is a statutory process to challenge certain decisions. And with all the understanding that one can give, ultimately the decision falls down that there isn't a basis for the appellant's appeal. Invite you to therefore reject that appeal, allow the respondent's cross appeal, and find that the decision on ground one shouldn't have been. One can now say that, remake that decision and say that there was no failure to provide a care plan in the circumstances, and therefore set aside the orders made by the judge at first instance as to ground one and as to costs. My lady, do you or your colleagues have any questions on which I can assist?
Thank you very much indeed, Mr. Wilson. Now, Mr. Wise, anything in reply?
Yes, I'll try and be as brief as possible, noting the time, my lady.
Well, I've just checked with my lord and my lady, and we're all available to sit till 1:30.
Good, right.
That's not encouraging you to take 20 minutes.
No, but I'll try to do it in quarter of an hour.
No, we want to hear what you have to say, obviously.
Of course. First point, my learned friend, was with respect to care plans not being litigated, and it's not for the court to say that they should do more than the number of hours, etc. Of course, we never asked them to do that. It mischaracterises our case altogether. Of course, we went to the tribunal in this case to resolve the detail. As the judge below noted, having been to the tribunal and having findings made with respect to that level of detail, it was incumbent upon the authority, the ICB, to put those into effect. The next point my learned friend made was with respect to the decision support tool. The decision support tool is a different beast than the care plan. It's a separate exercise. It's for determining whether a person has a right to continuing health care. There is no right to appeal to a tribunal in respect of a DST. The only right would be, the only avenue of redress would be to in judicial review. And the reality, it doesn't pretend to be a care plan, of course. What happens, as I think my learned friend alluded to, was that the information gathered with respect to the person being assessed is put into an algorithm, and the algorithm produces an indicative sum of care. It's the situation that the Supreme Court considered in the KM case, which we haven't got in court. We had it in the court below. That's a very different, and that gives a broad brush approach, which one understands, different than a care plan, and so it can't be relied on for care plan purposes. And so the indicative budget that was produced of 150k wasn't informed by a care plan. It was informed by the algorithm rather than an assessment of need and how that need was going to be met. Then my learned friend said, with respect to unjust enrichment, that we can't just cast a new species in this way. It is what my learned friend. Well, we say that we're not casting a new species in this way, and it's very important to note. My learned friend went on to refer to the ITC case at paragraph 44 about gratuitous payments. But he missed out the two crucial words in Lord Reed's speech in that paragraph, which were, for example. Lord Reed wasn't setting out an exhaustive list of the circumstances in which restitution can apply. Of course he didn't. He couldn't.
Are you an investment trust company?
Sorry, did I say?
Are you in ITC?
Yes, in ITC, paragraph 45. I'm not going to take you to it now, I haven't got time. But there's two keywords, for example. So it's not an exclusive list, even with respect to gratuitous payments. He simply doesn't do that, and wasn't invited to that, and probably would have been unwise to have done it. But we're not casting a new species, simply creating a new species of case. It may be that we're seeking to clarify cases, but just running through in the chronology of my learned friend submissions, and what happened. My Lord Justice Mayo said the parents had a choice. Well, it was a Hobson's choice, wasn't it? It was a choice to put the child at risk or pay themselves, and that is a situation that simply is unconscionable. But and one has to consider how that goes to the unlawfulness, unjustness, and potential remedy. We'll come to that in a moment. My learned friend then took the court to paragraph 29 of the judgment of the court below, saying that there was multiple factors. But when one analyses paragraph 29, none of those features, the difficulties that were in place with respect to the provision of care for this child, were the fault in any way of the parents of this child. It was all a conflict between the care providers and the ICB. Nothing to do with the parents at all. And when we look at that paragraph, we see that in quite clearly. So that was paragraph 29. And then one looks at paragraph 31 on the same page. During this period, the defendant has sought an updated healthcare plan for Aviva. Nurse manager of Aviva stated she was updating the care plan but wished to achieve clarity with respect to roles and responsibilities as nurses with the delivery aged care. And then goes on, at the meeting, Aviva agreed to share an updated working document of this existing June healthcare plan. So the court was well aware, as was the ICB, that there was this work taking place. My learned friend, we dealt with that point, that was the gratuitous point. My learned friend then came on to deal with CP. It was notable that my learned friend didn't mention paragraph 114 of the High Court's decision, where the deputy judge said it was a claim in restitution. And that hadn't, well, it's plain that it was a restitution case, and to somehow morph it into something else isn't, we would say, open to my learned friend and the respondent to this case. My learned friend referred repeatedly in the Court of Appeal judgment to breaches of duty that were found, and there were a number of breaches of duty found. Well, the only, if it wasn't a restitution claim, the only cause of action known in English law is breach of statutory duty, which we know is precluded by Exon Bedfordshire. We haven't heard anything from the respondent to suggest what the cause of action was. There is no statutory right that we're aware of or has been brought to the attention of this court for a recompense in the circumstances of CP. It simply could not have been a breach of statutory duty case. And in the absence of any other cause of action, it must have been a restitution case. That was what they said in their initial claim, and so that's what it must have been. The fact that it was a personal budget case is we say, a complete red herring. Exactly the same analysis applies, as we said earlier, whether it was personal budget or direct provision. And we make the point, our entire case doesn't hang on CP, even if the court isn't with us on CP, and the court may take the view that it was a breach of statutory duty or a claim on some other ground. We say that nevertheless we fall within the parameters of restitution and unjust enrichment, are entitled to entitled to that restitution. My learned friend said that this is creating a carve-out from X and Bedfordshire. Well, restitution is a remedy available in English law and has been available for many hundreds of years. It's not a carve-out from X and Bedfordshire at all. It's a right of citizens in this country that unless Parliament intervenes, can't be brushed aside. I mean, what effectively my learned friend's saying, when we're saying create a carve-out from X and Bedfordshire, is saying tantamount to saying that public bodies aren't subject to the law of restitution. There's no authority for that whatsoever, and of course the Surrey case shows that public bodies are indeed subject to the law of restitution. It's never, so far as we're aware, been said that public bodies are not subject to restitution. We then go to the cross appeal, and my learned friend relied on Citizens United, but of course the quote there was mainly was principally with respect to respondents and defendants to claims. But the real point is about the relevance of this August 24 document. We've seen that Miss Carrier took the view that it wasn't relevant. We saw that paragraph 3 statement of Miss Carrier, further supplementary bundle at page 116. Not only was the view taken it wasn't relevant, we also submitted that it wouldn't have made any difference. So for both of those reasons, the cross appeal should be dismissed. It was suggested that if that plan was before the judge, it could have been substituted, but that's not the case, because if one looks at the judge's full reasons at paragraph 60, I think it was, where he says it wasn't just the out of dateness, if that's an appropriate word, it was the failure to have updated in the light of the findings of the tribunal. Well, this later document doesn't update in the light of the findings of the tribunal either. As we've identified, the tribunal set out what care should be provided, 2-to-1 care, carers, nurses, and so on and so forth. This document doesn't do that. So exactly the same reason for the judge's criticism of the 2023 document, the June 23 document, applies to the August 2024 document. So it's inconceivable on analysis that the judge below would have substituted a document that was never claimed to be the care for fulfilling the statutory obligations of this public body for the one that was claimed to be fulfilling the statutory obligations of this public body. My learned friend then went on to the 3 cases we say on specificity and the quality of cases and the quality of care plans. And he says that there's no statutory basis for the assessment. There's a statutory basis for the assessment and plans in the A-B case. There isn't a statutory basis at all, based on guidance, just as in the present case. But the big picture point that's missed, if there's a care plan conducted for a severely disabled child, whether it's a statutory obligation or a non-statutory obligation, a non-statutory guidance, or a public body just does it. It doesn't matter where it comes from. If they do it, they've got to do it properly, and they've got to do it in a lawful manner, which meets the basic requirements of a document such as this, especially when a disabled child's life at risk. Now, we said that these cases show those 3 things about the assessment, the planning, and the provision. What's crystal clear from the cases is that a lawful care plan must set out who does what, where, and when. This document doesn't do that. Now, we can go into the detail what exactly they should have dealt with, what here, there, and in the different places, but it just simply doesn't do that. We set out all the, I think it was 7 points that they omitted to deal with. Those are all key factors in keeping my client alive and well. It doesn't say who does what, where, and when. So for all those reasons, we say that the respondent hasn't been able to satisfactorily deal with the submissions that we made. My ladies, my lord.
Thank you, Mr. Wise. Now, I think you technically would have an opportunity to reply. Anything?
I only want to say one thing, if I may, which is simply to agree with what Mr. Wise said, that an indicative budget is just an indicative budget. It is produced by multiplying things by each other. Whether you can deliver that, we have all seen that budgets in the state sector and every other sector are not necessarily deliverable. You can't. So I'd say that to assist.
Thank you. That's.
I'm obliged to my learned friend for that.
Thank you, Mr. Wise.
Great. My lady, thank you.
Thank you very much. Well, our interested party is sat quietly and presumably is remaining quiet.
Yes. Thank you.
Thank you all very much indeed. I'm very grateful. You've all worked extremely hard on this very difficult and challenging case. You won't be surprised to hear in those circumstances that we will be reserving our judgments. I know how anxious the parents will be, Mr. Wise, and we will try and get our judgments out as soon as possible, but obviously they have to be written up.
Yeah, we understand entirely. Of course.
When there's the opportunity. So you'll be sent.
Oh, I've just asked for completeness, though, when we get the draft judgment, which I know your ladyship was just coming to, can it be shared with the litigation?
If you hold your fire, I'll tell you that.
Sorry.
You'll be sent the judgments in draft.
Yes.
You're aware, obviously, that there'll be the terms of the embargo on top. Clearly, your lay clients must be given permission to and have an opportunity to read the draft. However, that must be done with their instructing solicitor.
Yes.
They're not to be sent electronic copies, not to have
Yes.
copies downloaded until it's until a draft is finalised, and
Yes.
then, of course, they can have complete
Understood.
access to
And
it.
just for those sitting behind me, just for complete clarity, father can see the draft judgment as well as mother.
I think I said the parents.
I think you did, yeah. I'll just be complete.
Yes.
Those
Of course, of course they must both. It's very important. Obviously, that's for typographical errors and minor infelicities. It's not an opportunity to re-argue the case, and I'd hope thereafter you'll be able to agree any order. Any difficulties about agreeing an order can be dealt with in writing, please. And thank you all very much, and those sitting behind, and the solicitors in the case as well, and of course the interested party. Thank you all very much.